This meeting is being recorded.
Morning.
Good morning. Right.
Morning.
Right. Good morning. So this is a very, very specialist and select band of individuals that are coming for the absolute teaching on the employing overseas workers. So this follows on. Stephen's just joining. Can I ask, was it tricky to get into the session this morning?
Just took a while. Said it was waiting.
While, right.
Just waiting for a few minutes.
Yeah.
But just
we'll start again in terms of the introductions, because I know Stephen's just joined us. You're the special audience that is coming for the immersion session on employing overseas workers. So I'm here today just to say welcome and thank you for joining us, and to introduce Alan Kennedy and Paige Lewis from Womble Bond Dickinson, who are going to run today's workshop. So we've already had an overview previously, excuse me, an overview workshop that was talking people through the principles, the issues to consider. This is a follow-up for those that are seriously interested in exploring the issue further and are looking at very practical advice as to how to do that. So before we start, both Alan and Paige are specialist lawyers in this area. And as I say, I'm going to walk through formally the process. The other thing that we've agreed for attendees at the workshop, they will also do a one-to-one follow-up to provide specific advice to you on any of the issues that you might be facing. So I'm here to do the welcomes and the thank you for attending, and then I'm going to hand over to Alan and Paige to deliver the workshop. We are recording the session because clearly we want to make this available to others that may not have been able to make it today. So before I leave you in their capable hands, can I do the round the screen introduction so that we all know each other? So first on my screen, it's you, Paige.
Thanks, Joe. Morning, everyone. I'm Paige. I'm an associate in the Employment and Immigration team at WBD, based out of Newcastle, but live in Penrith. And in terms of our immigration work, it's corporate immigration, so we deal with pretty much everything we're going to cover today. So we assist clients with sponsor licenses, visa applications, sponsor management, prevention of illegal work, and right to work checks. So we'll cover that today.
Lovely, thank you. Alan, you're up next.
Thanks, Joe. So my name is Alan Kennedy. I'm a managing associate at WBD. So we both work across the employment and immigration team, but I head up the immigration practice. And like Paige says, like we focus very much on supporting businesses with immigration issues. So it's very much the kind of corporate immigration side of things, but with that comes, like Paige said, the sponsor licenses, certain types of visas, you know, like the skilled worker visas, the global business mobility visas. We don't tend to assist individuals with things like applying for British citizenship passports, indefinite leave to remain, because that's more kind of, I would say, personal immigration, but all the other stuff we do. So hopefully we can run through a lot of that today.
Thanks, Alan. You and your next, please.
Hi, I'm Ewan Alcorn, one of the directors from MacArthur Recruitment and Port and Scale side Keswick. I mean, to be honest, I'm primarily interested to know a little bit about this, but it's really just to pick up information because I'm trying to have the conversation with some of my clients about using this as a route to employ people. So it's also good to know that you guys, you know, Paige and Alan are there as well, you know, so there might be, you know, I know where to turn to if clients need that as well. So thank you.
Thanks, Ewan. Stephen.
Good morning, Stephen Broughton, employer in South Lakeland, interested in trying to keep up to date with this particular subject.
Lovely to see you, Stephen. And we've not got you on the list for attending today, so Chris, over to you, please.
All right, thanks, Joe. Apologies for that. Yeah, Chris Cunliffe, I'm the Work and Skills Programme Officer at Cornwall Borough Council, and I coordinate the council's work and skills programmes. Some of the partners in our partnership support people from overseas and refugees, so I think it'd be good to get some in-depth information so I can kind of feed that back to members of the group.
Well, now you're not C. Pickles, we do have you on the list.
Yeah, sorry for the confusion, Joe.
Jen, over to you, please.
Morning, everyone. I'm Jen Hewitt and I am Executive Assistant for Cumbria Lep.
Thanks, Jen. And Ian? Sorry, Ian, you're on mute.
Sorry. Can you hear me now?
We can hear now. Yeah, you're off mute.
Oh, sorry. My name's Ian McGregor. I'm an employer in Keswick, and obviously I've got a sponsor license, but I've not been able to recruit anybody from overseas yet because the Home Office keep turning me back.
So that's the kind of practical issues that we want to explore. So now everybody knows everyone. Sorry for that, Ian, I think you joined as we just started. I was saying I'm just doing the hellos and welcome today because this is very much a hands-on practical workshop with Alan and Paige. Everybody that attends will get a one-to-one session as a follow-up, and Alan and Paige will organise that with you directly. We're going to record the session so that we can share it with others that couldn't make it today. And this is a follow-up to an earlier session that we had for a wider audience that was going through the principles. This is very much walk-through territory and an active workshop where Alan and Paige will respond to specific questions with attendees. So this is the specialist session for those that are super interested and want to understand more of the technicalities, if that makes sense. Yeah. Right. That is the time now to say thank you. I hope you have a useful and productive session, and over to Alan and Paige.
Great. Thank you, Jo. I'll just share my screen for you. Everybody see that all right? Has that worked?
Yep.
Yeah, perfect.
Yeah.
Thank you. Just checking that's on there. Brilliant. So as Jo said, we're obviously quite small in numbers today, so we can keep this interactive so that you can take as much as you can from the session. So what we'll do is we'll run through the sort of itinerary for the session. Me and I'm going to chat through some separate parts these workers and then prevention of illegal working. Questions shout up. We will stop at the end of each section and have some group discussions on some issues and ask questions as well.
Paige, sorry to interrupt. Yep. Your connectivity. You want to just try knocking your video off, sharing screen.
Is that better?
Strengthen your connection. It was just to let you know.
Oh, no problem. It's probably trying to do too much at once, isn't it? Let me know if it cuts out again.
That's a little bit better now, Paige. Yeah, I'll let you know if it keeps happening.
Oh, no problem. So I'm not sure how much of that you caught, but I'm saying because there's quite low numbers, we'll try and keep it interactive. So you can take as much from the session as you can. So feel free to shout up as we're going through. But at the end of each part, we'll sort of stop, have a group chat and ask questions then as well. So what we're going to cover today, I think everybody's new to the session, so I don't think we've got anyone from the last session, but that's not a problem because we're going to cover what we did in the last session in terms of the core principles like Joe mentioned, and then we're going to dive down into sort of more details as well. So we're going to look firstly at the sponsor license. We're going to look at compliance duties, what the criteria are to apply for a license and the process how to do that. We're then going to look at visa applications. We're going to quickly look at some other immigration routes, but we're going to focus on skilled worker and senior specialist worker, which you might have previously heard referred to as the intra-company transfer. They're the more common routes into the UK. But the general principles around sort of valid applications and the suitability for those apply to others as well. And then we'll have a look at the application process. We'll then have a quick comfort break. And then the last section, we're going to look at prevention of illegal working. So that's right to work checks. There've been quite a lot of changes recently to the rules and the guidance around that. So we'll have a look at the different checks that can be carried out. And then finally, we'll have a look at avoiding discrimination during the recruitment process. Before we do that, then I think it's just useful to consider why we're talking about this today. And I think Joe touched on the point just then. Obviously, the labour market at the moment are facing some staff shortages. And I know there's a lot of businesses and industries within Cumbria that are. Oh, am I going back? Can you still hear me?
Yeah, just about. Yeah, it's okay. It's a bit crackly, but it's okay.
So obviously, there's businesses in Cumbria that are experiencing these staffing challenges as well. There's a lot of potential in the international labour market that employers, want to be utilising to fill these shortages. And so the purpose of today is to give you sort of a grounding and an understanding as to how you can go about doing that and the legal requirements for it. Before we get into the complexities of the sponsorship process, we thought it might be useful to just consider some practical tips in terms of attracting and retaining talent. This is with a focus on sort of international labour, but it also applies to the wider, recruitment market as well. We find that people more and more are expecting more from employers, and this is just some of that sort of some tips there really as well. So in terms of attracting international talent, then relocation packages is one thing we could consider in terms of supporting people moving over to the UK. It's also worth considering what you've already got at your fingertips in terms of existing employees that can offer support to international talent as well. So if there's language barriers, for example, anybody you can appoint within your organisation as a point of contact for people moving over from the UK. So for example, to provide local knowledge, where to live, driving lessons, whatever it might be, that point of support can be quite invaluable. It's also worth considering what policies and practices you have in place. There's a legal requirement to have equality policies, but it is recognised as good practice. And the aim of such policies is to promote the message internally that you're an employer that values diversity. Administrative support, so again, just considering what you might be able to offer to people moving over to the UK in terms of setting up bank accounts, the visa process that we're going to look at today, considering what training as well you offer to existing staff already, just to promote that inclusive workplace. And finally, just having to think about any wider initiatives that are available to your organisation to use that you can sort of obtain support and guidance from. So for example, the Race at Work Charter was launched back in 2018, and that has the aim of tackling ethnic disparities in the workplace. So they're all useful sources. So they're just some practical things to think about, but we'll get on with the more complex side of things. So I'll pass over to Alan, who you can hopefully hear better than you've heard me, to talk about the sponsor license.
Thanks, Paige. And yeah, if it's crackly on my end, just let me know and I'll take the video a bit off it. Hopefully it'll be okay. So yeah, so and Paige, if you could click through the slides when we go through it, that'd be really helpful. But the first part, yeah, I mean, the first part we're looking to talk about was, you know, it's almost separated in three parts this session. Looking at sponsor licenses first, because we'll come on to this in a second, but you can't necessarily recruit overseas migrant workers on certain routes if you don't have a sponsor license in place. So we're going to go through the ins and outs of a sponsor license, and then obviously part two we'll look at the visa requirements, how you apply for a visa, because that's where the main sort of action happens, I guess, in terms of getting the individual over from an overseas country to the UK. And then the last part, the part three, is right to work checks, because that is quite a hot topic area at the moment. There's lots of changes. There's lots of clients that are falling foul of right to work rules, of the right to work rules, which can have, you know, it can cause issues, because at the end of the day, companies can fall foul of illegal working, which is something we want to avoid. So yeah, so the starting point is really to go through what is a sponsor license and how to obtain one. And I think Ian, you mentioned on the call at the start that you guys already have a sponsor license in place. So the application side of it, which we'll discuss, might not necessarily be relevant, but there's going to be bits in here that are relevant, which is all about like sponsor management duties and compliance, and how you make sure you keep hold of your license, because because you know, if you don't follow the rules and the guidance, that license can be revoked. So that's the aim of the first part of the session. If anyone has any questions when we go through this, just honestly shout up. You know, there's a small group this morning, so I would much prefer if you just sort of interrupted me, and, you know, don't feel rude, just speak over me if you want to. Just shout out if you've got any questions and we can go through it. So, and the last thing I would say is we're going to cover a few things on the sponsor license. I'm trying to give an overview. If you look at the actual guidance on the Home Office website, it's massive. There's lots of different links. There's lots of different guidance on how to apply for a license, on how to sponsor a worker, how to sponsor a worker on a specific route, your sponsorship duties and compliance. There's lots and lots of information on the Home Office website, almost too much, I would say, which can be a bit overwhelming. And also, and this is a bit of an immigration lawyer's nightmare or headache, a lot of it is guidance. So there are such things called the immigration rules, which set out exactly what the immigration rules are, like the legislative rules on it. But really what the Home Office expects employers or sponsors to do is follow the guidance that they put on their website, which is good, because it's better to have probably too much than too little. But the guidance is quite difficult to understand at times, and it can be interpreted different ways. But the problem is, if you interpret it the wrong way, the Home Office can kind of come down on you quite severely. So it's good in one sense, but not in another. So just to kind of start on the first slide, I just wanted to highlight, I suppose, and that quote from the Home Office guidance is basically highlighting that when you look to become a sponsor, we have a lot of clients that just think, well, actually we'll become a sponsor and it won't really involve much, and it's a tick box exercise. And it is to a certain extent, but to another extent, you know, the Home Office are really they take sponsorship very seriously, is probably the best way to say it. And you know, the fact that they've said there that the ability to sponsor is a privilege and it must be earned, you know, these are kind of quite sort of severe wording, really. And you know, when a sponsor is granted a license, significant trust is placed in them. And so, you know, they're using words to make it clear that if you do become a sponsor, you can't just sort of take the view that I'm a sponsor, we can get someone in from overseas, and that's it. You know, that's all we have to do. We don't have to do anything. We don't have to manage the license. It's not quite like that. I think if you become a sponsor, you need to take into account that, you know, there's lots of things that come with it and lots of regulatory side of things. So that's what sort of that first slide is sort of trying to say. And what the Home Office expects you to do if you become a sponsor is, you know, you can't abuse the immigration system, which I'm not saying anyone would, but some employers do, because when they get a sponsor license, we've had clients before that have abused the system and have lost their license as a result. But you've also got to comply with wider UK law. So there's a greater scrutiny on you if you've got a license. There's a greater expectation, that you know that you know about the rules and the guidance, and you've got to not behave in a manner that is not conducive to the public good. So you've got to act in the public interest, basically. And what they also say is that, you know, if we do look to recruit overseas nationals, those overseas nationals have to be eligible and trustworthy, and the licensed employer has to genuinely wish to employ and sponsor them. You know, and we've had clients before that have come to us and said something like, we've got an individual in the, and this sometimes is okay, but we've got an individual in another country, their visa's about to expire, it's going to take them another year to get that visa renewed, we need to find them a place to live for a bit. Can we apply for a sponsor license and a visa in the UK? You know, and that's the bit where, are we abusing the system by trying to get a sponsor license to fit a situation, or do we genuinely want this individual to come over to the UK because there's a job for them to do? And I think that's the key on all of that. And like I say, the rules can be complex. There's a high burden on sponsors to comply with the rules, and non-compliance can result in harsh penalties, fines, revocation, you know, reputational issues, things like that, which I'll come on to in a second. But I think the one thing I would say is it is important, because if you do, say you sponsor a number of individuals on your license, say you had 10 migrant workers on your license, if you decided, or if you fell foul of the immigration rules for whatever reason, and the Home Office revoked the license, all of those individuals would have their visas curtailed, and they would have to leave the country or find another sponsor in 60 days. So, you know, that's why I say that the penalties for non-compliance can be quite harsh. So Paige, just on the next slide. So on the next slide, when it comes through, we talk about, you know, what is a sponsor license and why do employers need one? And this is quite low level, I suppose, but, you know, starting from the basics, you know, it's obviously, you know, a license is given when an employer wants to sponsor overseas workers. And I think when you are in a position where you think, we want to sponsor an overseas worker under a specific work route, and that might be to fill a skills gap or skills shortage in the particular business or sector, but where you've identified that you need to recruit from overseas, then you need to start thinking about, do I need to become a registered sponsor? And Paige is going to mention various routes and routes where you don't require sponsorship, but where you have identified a route that requires sponsorship, then you obviously need to become or apply for a sponsor license to become a sponsor. And I think, you know, everyone will be aware of this, but it has become a bigger issue since Brexit. But pre-Brexit, sponsor license were kicking around still. There was lots of organizations had sponsor licenses, but probably less because we only really needed them for non-EU workers. So, you know, any individuals that were not either British or European, that's where you're thinking you need a sponsor license, because they're classed as migrant overseas workers. Now Brexit's happened and free movement's come to an end. You know, that now applies, the requirement to have a sponsor license now applies for EU workers. You know, and yes, you might have an EU worker that's got settled or pre-settled status. They don't need sponsorship. I think that's quite well known. But if you've got an EU worker, so if you want to recruit someone from Germany, say, that doesn't have settled or pre-settled status, then you need to start thinking about, well, actually, they're going to need a visa, and we're potentially going to need a sponsor license as well. So it's kind of opened up the net much wider as a result of Brexit. And like I said, not every worker requires sponsorship. So you might have an individual that you think on the face of it, right, they're not from the UK, they say they're from America, or their nationality is American. You might think, well, actually, we need a sponsor license here. But it really depends on the route that they're going to apply into the UK for. So, you know, there's been a new visa route called a graduate visa. So students that have graduated can now apply for something called a graduate visa for 2 or 3 years, which basically allows them to stay in the UK for that period without sponsorship. So you wouldn't need sponsorship for those individuals. At the end of that period, if they were then to go onto a different route, then you probably would. But you've got other people like youth mobility visas, or maybe an individual comes over to the UK as a dependent. That dependent wouldn't necessarily need a sponsorship. So there are some routes where you wouldn't need it. But when we talk about sponsorship, the main 2 routes we're really talking about, and these are the most 2 popular in the UK, are firstly, you've got the skilled worker route. So that's, you know, as it says, you know, the majority of overseas workers are sponsored under this route, and it requires a skilled job which is paid at a certain level. So that's definitely the most popular route in the UK. And then you've got something called, and it's a recent name change of name, but it's called a Global Business Mobility route, so the GBM route. And there's 5 separate subcategories under this route, which Paige will be going through in you know, later on. But the most popular one is something called the Senior and Specialist Worker route, which is, it used to be called ICT, intra-company transfer. And as it, you know, as it says there, it's, you know, it's for companies who have overseas branches who want to transfer skilled workers from a linked overseas entity to a UK entity. So, you know, say you've got a branch in Japan, say, and you've got an entity in the UK, and you want to transfer individuals from Japan over to the UK for a limited period of time, for a couple of years, to carry out a skilled job, then you'd be thinking, well, actually, can we utilize the ICT route? So they're the 2 most popular routes. So if you're thinking we're going to utilize that, we're going to need a visa under either of those routes, then you are thinking we need, you know, you need to start thinking we need a sponsor license. And I'll go through the process to apply for a sponsor license in a second, but generally, you know, there is a cost to apply for a license, but it's generally either, as it says on the slide, £536 for smaller charitable sponsors and about £1,500 for medium to large sponsors, and that lasts for 4 years. So when you get your license, you pay that fee, you get it for 4 years, and then at the end of that 4 years, you've got to renew it and pay the same fee again. And you might be thinking, well, would we fall as a small or a medium or a large? And there's specific rules around what is defined as a small company, and it's defined in the Companies Act, but in general, it's where you've got an annual turnover of 10.2 million or less, and it's 2 out of 3. You've got to tick 2 out of 3 of these boxes to be small. So annual turnover 10.2 million or less, total assets 5.1 million or less than, or you have 50 employees or fewer. So if you tick 2 of those boxes, then you'd be classed as a small employer, a sponsor, and would have to pay the fee of 536. Anyone else would be the 1,500 fee. And then just in terms of, like, once you've gone through everything and you've applied, the general wait time is around 8 weeks. So, you know, you put your application in and you have to wait 8 weeks for the Home Office to come back with a decision on the sponsor license application. And there is a new priority service that you can use. You know, you can pay an extra £500 to get a decision within 10 days. What I would say, though, is it's a first come, first serve basis. There's no guarantee that you can use the priority service. And it's basically done on a daily basis. And, you know, you might think, well, it'd be quite easy to do that. But, you know, most people that are applying for licenses are there at 9 a.m. pressing click ready to submit. And it's a bit of a lottery. But there is that option there if you need it. But I would always, if I was applying for a license, I would always factor in that it's going to take up to 8 weeks. It might be less. It might be less than that. You might get within the 10 days. You might get in the priority service. But I would always sort of, the starting point is always to base it on 8 weeks. So Paige, on the next slide, we're just kind of going through on the next slide what it actually means to be a sponsor. So when you actually obtain this, and this will be more relevant for Ian because he's got the license at the moment, and you'll probably be aware of all of this. But when you get the license, then you're under greater scrutiny. That's a definite, because you're on the register of sponsors. You're under the spotlight of the Home Office, and with that comes various compliance duties. So what I mean by compliance duties is, the 4 bullet points on the slide, but the most important 2 are record keeping duties and monitoring and reporting. So what I mean by reporting is, when you have a license, the Home Office expects you as the sponsor to manage your license through something called the sponsor management system, which is a short version is SMS. And it's an online system where you basically go in. If you've got access, you can only go in if you've got certain access, but you go in and you manage the license, and it's got all of the things that you can do with the licenses is via that SMS. And what the Home Office expects you to do as well is, if there's certain changes that have happened with your migrant workers, you've got to report certain things to the Home Office within 10 working days. And again, if you don't do that, you could face penalties and have licenses revoked and on-site visits and things like that. So what they say and what the rules specifically require is that within 10 working days, if you have a sponsored worker that doesn't start their role, or they've been absent for 10 days or more, you've got to report that. Where there's been significant, and I think this is the main one, where there's been significant changes to the individual's employment. So if they've moved into a different role, for example, or they've had a reduction in salary, that's a really important one where you have to report it to the Home Office. And the reason for that is, under certain routes, you have to have a certain job, you have to have a certain skilled job, and it has to be paid at a certain salary. So if any of those things change, then you've got to let the Home Office know, because it could affect their visa status. If their employment ends earlier than shown on the certificate of sponsorship, so their period of sponsorship, if their employment ends before that, you've got to report that. And where you've got any workers that are affected by TUPE, and the reason for that is because their employment would be effectively transferring to another employer who would then need to apply for a separate sponsor license. They also ask employers to report certain things within 20 working days. And this is more company related, so it relates to things like a change in company name, if the company sells parts of its business, so if it's involved in a sale or purchase transaction, or a merger, because again that affects the dynamics, the structure of the business, which could affect the license, or where the company goes into insolvency. So they all have to be reported within 20 working days. And another thing as well, which I think a lot of our clients, well, not a lot of our clients, but some of our clients do fall foul of, is where there's a change in the people who manage the license, which I'll come on to in a second. That also has to be reported to the Home Office, because the Home Office want to be confident that they know who's responsible for the license and who's managing the license on a daily basis. And it's very much comes down to a trust and confidence type thing. So if that changes, we need to be notifying the Home Office. In terms of record keeping duties, it's exactly what it says there. Sponsors are required to keep records of documents and things to do with migrant sponsors and migrant workers. They've got to keep records of that securely stored in a specific place. And the Home Office is really hot on keeping robust record keeping duties. It's a really big part of being a sponsor. And what I mean by that is keeping things like up-to-date contact details for each migrant worker. I mean, that's essential, and probably something you'd be doing anyway. Have an evidence of the individual's immigration status and right to work, so to ensure we're not employing someone illegally. Keeping employment contracts and any offer letters on file, which I think hopefully we'll be doing. Keeping evidence of any absences and change in circumstances, so that's quite a specific one for the license. And then keeping evidence of how the worker meets the requirements of the specific job, which should ultimately be like a job description, supporting that they can do a skilled job, and any qualifications and things like that. And the importance of having all that on the system, because you might think, well, why do we need that? Who's ever going to check? Well, the Home Office can actually just come unannounced and do random on-site inspection visits. And it does happen quite a bit, where the Home Office will knock on the door and say, we're the Home Office, can we speak to your key personnel on the license, and can you show us all the documents that you need to be kept securely? So they can do that, and we've got to give the information promptly, and we've got to allow them access to premises to carry out the audits and compliance checks. But it's important we do all that just in case that on-site visit happens. And like I said at the start, any failure to meet any of the duties can result in enforcement action, which can result in fines, reputational issues, revocation of the license. So Paige, on the next slide, I've just mentioned some real practical tips. I mean, I think that the key tip, if you're speaking to your own clients or you're looking to apply for a sponsor license, is it's always planning and preparation and understanding what's required. I think if you know you're going to need to sponsor someone in the future, or you've identified a certain skills gap in the market or in the business, then you've got to factor in the timescale that's going to take to get a license. I mean, generally we will get people coming to us and saying, we want to recruit someone and we want them to start next month. And we say, have you got a license? Oh, we haven't got a license. That's going to be difficult to get someone, into the UK in a month's time, given the timescales associated with all of this. So preparation and planning is really key. And I think you also need, not just the 8 weeks to get a license, you've also got to factor in the time it's going to take you to get the information for the application form, and all of the support and documents which you need to submit with the application. So there is quite a bit to do to get a license, and timescales to be aware of. And there are situations where there could be delays in all of this as well. And sometimes when you apply for a license, the Home Office will do a pre-sponsor license compliant visit. So not always. So when you apply for a license, sometimes the Home Office will just grant the license based on the application. Sometimes they'll want to do a pre-site visit, and that's usually with startup companies. So where you've got a startup company where they're not 100% confident that they've got a trading presence in the UK, for example, or there's some doubt about the documentation that they've submitted, again, because they're a startup, they might not have all of the documentation, then a site visit is probably more likely in that situation. And the Home Office does say as well that they generally will do pre-license visits in more high-risk sectors, and that includes things like catering, hospitality, and IT. And the only reason they're more high risk is because there is, I suppose, more of a historic reputation of non-compliance. So in those sectors, they're more likely to get a pre-license visit from the Home Office, which you obviously want to try and avoid that, but you've got no control over it. But it would delay things, because the Home Office would have to come and do a visit, go through everything, which adds time onto the license application. We also see delays where clients have submitted the license and they haven't provided all the information or the documentation. All that really happens there is the Home Office is either going to reject the application and say apply again and send the right documents, or it's going to write to the applicant and say provide the documents and you've got 5 days to do it. But either way, it causes a delay. And the only other thing to factor in as well is if you don't do the application right and the Home Office doesn't have trust in what you've provided and isn't confident that you're going to be a responsible sponsor, then they could refuse the application and you would be subject to a 6-month cooling off period. So you couldn't apply for another license within that 6-month period, which would be a real problem if you had, either if you had a certain individual that you needed to get across on a visa, or if you had a contract, for example, where you had to recruit 50 employees from another country to carry out a specialist type of work for a contractor, then you've got a real problem if you're then subject to a 6-month cooling off period, because you can't do that. So those things are things to be aware of. At the outset as well, it's also important to think about the type of route that you want to get a license for. Sorry, so it's not just we need a license and the license will cover everything. You have to apply for a specific route. So are you applying under the global business mobility route? Are you applying under the skilled worker route? Are you applying under a different type of route? So it's important to understand what route you're actually applying for. And you're not restricted to that route. So if you decided you wanted to add a different type of route onto the license, you can do that, but you just have to do another application, which is basically a short form application. The other thing as well is when you apply for the license, and this is really important that I don't think our clients sometimes understand, but what you have to do is you have to present, and this is what the Home Office expect us to do, is present a robust business case illustrating exactly why you need the license. So this goes back to the kind of tick box exercise point I mentioned at the start. It's not that straightforward. It can't, well, we need a license, so we'll put in an application and we'll get one. You have to have a good business case. You have to demonstrate to the Home Office how you're going to be a responsible sponsor, why you need the sponsor license, and why the individuals that you're looking to bring over are eligible for a visa. So I think those are all the things that you generally try and cover and include in the application form. And that's to basically make sure that the application doesn't fall foul of something called the genuineness test, which is what the Home Office will always look at. So is it a genuine application? Is it a genuine sponsor license requirement? And then the other thing, which I'll come on to this later on, but you'll need to think about who's going to manage the license and who's going to operate it on a day-to-day basis, but that's really key. So I'll discuss that in a little bit more detail shortly. But the only other thing I would say is that depending on the type of structure that your business is, there's various ways that you can apply for a license. So if you have multiple branches or sites within the business, then there's different ways of applying for the license. So you can apply as a single sponsor license. So you can apply for a single sponsor license that covers your head offices and all branches underneath it. So that's one way. You can apply for a single sponsor license that covers the head office and just some branches, or you can have a separate. So you can have a separate license for the head office, and then each branch has its own licenses. Or you can group a number of branches under a single sponsor license. So the Home Office is happy for you to do this in various different ways. The one thing I would say though is that if you have a single sponsor license that covers everything, if one license goes down, everything will go down. That's probably the easiest way I could try and say it. You know, if you had one license, if there was, so if one of your branches in the license did something that fell foul of the immigration rules, then all of the branches under that license will be affected. It's just how that's how it would work. But if you had separate licenses for each different type of branch, then everyone's kind of on its own, you know. So a significant breach by one branch wouldn't then affect a sponsor license for another branch. What I would say though is the Home Office wouldn't just turn a blind eye to it. They would probably look at it and go, well, if they're all part of the same group company, maybe there's an issue with the group company and not just that entity. But the main thing is it wouldn't have an automatic effect on it, but the Home Office would probably still look into it. And another question I often get asked is, does the organisation, so it has to have a trading presence in the UK, but does it need to, does it actually need to occupy a premises in the UK, or could it be a virtual business model? And I think that's probably, we're getting asked that a bit more since the pandemic with remote working and things like that. The short answer is you can. So you don't have to have an actual premises in the UK to apply for. So you could have a virtual business model. So you can still apply for a license. But as you're probably going to expect me to say, the Home Office is going to, you know, look at this as under a magnifying glass. It's going to look at it in greater scrutiny, because it's going to want to have, you know, it's going to want to have evidence that you can still meet all your sponsorship duties. You're still operating and trading lawfully in the UK. There's probably a higher chance to do an on-site visit, and you're probably going to say, well, where's it going to visit if we don't have a premises? Well, it would visit the address of the authorising officer on the license, the person that's responsible for the license. They would go and visit that person's home address and go through the application in a bit more detail. And basically what they would be expecting to see is adequate systems in place, and making sure that even though you don't have a premises in the UK, you're still a responsible sponsor. So Paige, just on the next slide, we're just going through sort of eligible. So one of the big things with the application is that, you know, when you apply, you have to meet certain eligibility and suitability criteria. So the eligibility criteria is quite straightforward. You know, it's basically you need to provide documents, so documentary support and documents to show that you are, or the organisation is genuine and has an operating or trading presence in the UK. So the Home Office will expect you to provide documentary evidence to support that. And things that we can provide are things like evidence that we've got employers' liability insurance, financial and audited annual reports, audited annual accounts, registration with HMRC for VAT, registration for PAYE and national insurance, company tax returns, and business bank accounts. So things like that will show the Home Office that we are genuine and have an operating or trading presence in the UK. So they are, you know, pretty much mandatory. Not all of those documents, they're just sort of a flavour of, you know, we might have to provide 3 or 4 of those documents, but that's the sort of thing the Home Office would expect us to do, because if we don't have an operating or trading presence, then the application will be refused. It's pretty much as straightforward as that. Page on the next, and then and then the genuine vacancy, you know, as part of this goes back to the business case as to why we need the license. We need to demonstrate to the Home Office that we need the license to actually recruit someone, and that we have a genuine vacancy in the organisation for an overseas migrant worker to fill, which is, you know, a skilled job, etc., at the right salary level. So on the next slide page, the suitability criteria is more relevant, I think.
You said we could interrupt.
Yeah, of course. Yeah, fire away. Of course.
Do you have to provide proof that you have maybe tried to recruit for that role in the UK and there's nobody here available, or what's the?
Yeah, so you used to, before Brexit, it used to be something called a resident labour market test, where you actually were under a lot more scrutiny and you had to advertise the role for 28 days, and you had to show that you would give settled workers, so people that are in the UK settled, the opportunity to apply for the role. And that was really strict. You know, if you didn't do that, then you wouldn't be able to. Well, it would be a breach of the immigration rules, and the individual wouldn't be able to get their visa. But that's all been abolished now, so you don't have to. There's no such thing as the resident labour market test, which is a good thing. But what you do have to do when you apply for the license is that it does ask various questions. It will ask various questions about the role in question. So if we are looking to recruit in the future, it'll say, what type of job are you recruiting for? What SOC code? So like all of the skilled, under the skilled worker route, there's various different types of SOC codes. So it'll say design engineer, SOC code 2126, and then it'll say a different type of role, different. So you've got to then, and you've got to do say what the job description is, except, to show that it's an eligible job. In terms of like, have you attempted to recruit for it? There is a question in there that does say, explain how you have recruited for the role. So we've got to, but we don't have to say, well, we advertised this in the UK and no one applied for it, and therefore we went out to the international market. That was the resident labour market test, which is gone. All we have to say now is, why we are looking to recruit overseas. And it might be that there's a shortage, and it might be that the individual from overseas has the skills that we need. It might be that there's a shortage of skills in the UK in a certain part of the business. But yeah, and they sometimes ask for job adverts, like, have you advertised the role? I don't think they would be a sucker punch to any application, but I think if we are able to provide that information, we would do as part of the application process.
Okay,
Does that answer the question?
Yeah, absolutely. Yeah. So it's basically a lot easier than it used to be.
Yeah. Oh, yeah. The resident labour market test was a nightmare. It was
Yeah.
because you would go through that process, and you would advertise it for 28 days. You potentially have someone in mind overseas that was the right person for the job. Then you would have a settled worker that went through the process, had all the skills, and you would have to favour the UK, the settled worker, over the person you probably had in mind, which would cause the difficulties.
Yeah.
But that's definitely all gone now.
Okay, fab. Thanks, Alan.
Great. And then, so in terms of the suitability criteria, the main thing there, I think that most people, well, the third, fourth, and fifth one, sorry, yeah, the second, third, and fourth bullet point on the slide are fairly straightforward. I can kind of whiz through them because, okay. So just having a look at one of the questions there. So yeah, when we apply for the license, you've got to make sure that none of the directors have any unspent criminal convictions that relate to an immigration offence. You've got to make sure that there's no evidence of previous non-compliance by the organisation. So you might have had a sponsor license in the past and it got revoked, or something happened, it got downgraded. So, most of those things generally won't happen, or you'll be aware of that before you apply. The main thing really is the first one, which is having robust HR and recruitment systems in place. I don't think this has to be like overkill. It doesn't have to be, well, okay, we're not Asda or Sainsbury's that have got a huge HR team that have got 50, 60 policies on the stocks that apply. We're not really talking about that necessarily, but we have to have some kind of system in place which allows us to meet and manage our sponsor duties, and the Home Office will expect us to have that in place. And if they ever carried out an on-site visit, they would want the person responsible for the license to go through that, and it will be scrutinized. And I think what we're talking about in terms of what do we mean by HR, I mean recruitment systems. Do we have a recruitment policy? How do we recruit individuals? What's our process? I mean, I don't really think it needs to go any further than that. Really, what into advertisement, application, interviews, offer letters, contract, it's that sort of thing really. And human resources, how do we store documents? So if a migrant worker comes over and we've got a copy of their passport or visa, what systems do we have in place to store that? And if they only have a time limited right to be in the UK, so say they've got a visa for 3 years, what systems do we have in place to make sure in 3 years' time we know that we need to do something? So it's that sort of thing, really. And like I mentioned before, if an individual is absent, do we have a system in place that manages that, so it doesn't just like sort of drift into, you know, days and days and days where we don't know how long an individual's been off for. So it's having systems in place to deal with all of that. That's what we mean by the suitability criteria and robust HR and recruitment systems. As I say, there might be on-site visits to check that, where they might do on-site visits when you have the license. So for someone like Ian, the Home Office could come and knock on your door at any time and check that you're complying with your duties. So it's not just when you apply for the license, it's an ongoing thing. So it's important to get that bit right. On the next slide page, and we've only got a few more slides just to quickly cover off before I'll pass over to you. But on the next slide, really important is the key personnel. So you've got to, when you apply for a license, you've got to have the first 3 bullet points. So almost forget about the level 2 user. I'll mention it, but it's a choice, the level 2 user. But you have to have an authorizing officer in place, and that person is usually the most senior person within the organization that's responsible for recruitment in HR. So that person's ultimately responsible for the license and the activities of all of the other key personnel under them. So if there's a problem with the license, it will fall back on the authorizing officer, which is why it's the most, as I say, the most senior person. Then you've got a key contact, who is basically the person that's the contact between the business and the Home Office. So if the Home Office ever had any questions about the license or the application form, they would speak to the key contact first. And then you've got a level 1 user, who, you know, is the person that manages the license on a day-to-day basis and that accesses the SMS. And the level 1 user can be a number of, so you can only really have one level 1 authorizing officer, you can only have one key contact, but you can have multiple level 1 users. The only other thing I would say as well is that you could have just one person as the authorizing officer, key contact, and level 1 user. It doesn't really necessarily matter how you do that. But the main thing to be aware of is that the key personnel have to meet certain suitability requirements. So they have to be permanently based in the UK throughout the duration of their role. They've got to be a paid member of staff or engaged as an office holder. And there's some exceptions to that, which, so for example, we wouldn't be a paid member of staff for the organisation, us WBD, but we could still be on the license as a key contact or level 1 user. So there are some exceptions for like legal representatives. We could never be the authorising officer, but we could be the key contact or level 1 user. And then also none of the key personnel can have unspent criminal convictions. So they're them, and they can't, you know, if you've got a company director that's going to be a key personnel, they can't be legally prohibited from being a company director. They can't be subject to any bankruptcy orders. It can't be a contractor. As I say, it has to be a paid member of staff. So you know, you've got to get the key personnel right, because if the key personnel's wrong, again, the Home Office are really hot on that, because it's a trust thing. If they trust your key personnel, they'll trust that you can manage the license. That's generally how it works. So just on the next slide page, in terms of the sponsor license application, I'll just quickly run through this, but the license application itself is not that difficult. It's, you know, it's a form that you have to fill in online. It asks details about the company, what route you're applying for. As I said before, whether you're applying as a single entity or part of a number of branches, whether you've got overseas branches that you want to link to the license for the ICT, the intercompany transfer stuff, and details about your key personnel who will manage the license. You've got to submit the application yourself, so the company has to do it. A legal rep like us, we could complete the application for the company, but we couldn't submit it on their behalf because it would definitely get rejected. The Home Office make that really clear. It has to be done by a representative of the organisation. When you submit the application, you have to submit supporting documents. So you have to submit at least 4 supporting documents, and there's something called Appendix A on the Home Office website that lists all of the different documents that you will need to submit. And you know, which documents submit will ultimately depend on what route you're applying for and the type of organization you are. So if you're a startup organization, you have to provide certain documents. If you're applying under the ICT route, the intercompany transfer route, you have to provide a certain document that shows the link between the overseas company and the UK company. And then there's a whole load of general documents which I mentioned earlier, like the annual returns, like the company tax returns, those sort of things. So you've got to submit at least 4, but they have to be the right 4. Otherwise, again, the application will be rejected. And then after you've so on the next slide page, after you've submitted the application, what you've got to do is you get something called a submission sheet. So that has to be signed by the authorizing officer, and it has to be sent as soon as the license. Well, you've got 5 days, but as soon as the application's been submitted, you've then got to complete the submission sheet, sign and date it, and get that submitted to the Home Office. You've then got to submit all of your supporting documents, like I say, within 5 days. And if all goes to plan and you get a positive decision, the Home Office will write to you and give you they'll give you something called an A-rated sponsor license, which basically allows you to start assigning certificates of sponsorship, which is what you need to do to recruit overseas workers. And like I say, if in the worst case scenario it gets rejected or refused, the Home Office is either going to allow you to correct the error that you've made on the application form. If it's like a minor issue or you've submitted 3 documents, not 4, they might give you an option to correct that error, which would be the best situation. If they think the application is so bad that it can't be corrected, then they'll refuse it. And as I say, you'll be subject to a 6-month cooling off period, so you can't apply within that 6 months, which is the worst case scenario. And it doesn't often happen, but we have seen that happen before. So I know that's a whistle-stop tour of sponsor licenses. I hope it kind of gives you a decent flavour of what's required and the ins and outs of it. It's a complicated area, but I think the main message is to properly plan, prepare, and just factor in the time that you'll need to apply for it. So that's all I wanted to say. If anyone has any questions, you can ask now or at the end. Otherwise, I'll pass over to Paige.
Brilliant, thanks, Alan. Right, so the visa application then. So following on from what Alan said, once you've got your license in place, you've decided which route you've got on the license, you then need to obviously apply for the visa, and you can only do that once you've got the license in place. Like Alan mentioned, it's at that point that you can get a certificate of sponsor, which is an important document, and I'll talk about these later on. But you have to have a license to get that certificate to be able to.
Paige, it's just a little bit crackly. I'm sorry to flag.
Not really sure what I can do. Let me turn my camera fully off. Is that any better?
It's still quite crackly.
If I leave and rejoin, should I try that?
If you do what, sorry?
If I leave and rejoin.
Yeah, you could.
That's
probably it's probably a good idea.
Right, give me 2 seconds. Sorry.
No, it's all right. Was it crackly for everyone else there?
Yes, yeah.
Yep. Unfortunately, yeah.
I think the weather actually over the last 2 days has caused a bit of interruption.
Alan, could I ask a question while we're waiting for Paige to rejoin? Yeah. Just something that's coming across. It might be covered later on, but there seems to be an awful lot of onus on the employers to get everything in place. Within our role, we support lots of people going into work, and for various reasons, sometimes it doesn't always work out. I'm just wondering, because it looks as if employers have to, there's a financial outlay for employers as well as all the documentation and compliance that they've got to adhere to. Whether they can kind of de-risk the situation, in terms of have they got the right person for their business, And it's those kind of things really that's just
Yeah.
kind of crossing my mind, which employers might be wondering about.
Yeah. So like, yeah, there's, and I guess a large part of that comes down to the recruitment process, you know, in terms of, is this the right person? Like going through a robust recruitment process would hopefully address some of those questions. But then, you know, you never know until the person starts working for you, who you've, you know, and I guess there are costs associated with it. So I don't think there's any way to kind of get around the sponsorship stuff, because or the sponsor license stuff, because I think if you've identified someone and you've gone through the recruitment process, you've then got to obviously decide, right, well, we need a sponsor license, so we're going to go down that route. You apply, and the sponsor license isn't just specific to that one individual, you know, so the sponsor, the Home Office would never look at it in terms of, well, that sponsor license is just for that one individual. It's for the organization to recruit in general over a 4-year period. I think when you start talking about the visa stuff, which Paige will come on to, it's a little bit different, because there's things like application fees, visa application fees, immigration health surcharge, and there's other visa costs associated with it. You can potentially look to try and recover those costs from the individual. I mean, the organization might not pay for those costs. The organization might say, well, actually, it's the individual's visa. They need to pay for the cost. But I think what we generally see is that the employer will pay for the costs, and then they'll sometimes look to try and recoup it back, a bit like training costs. So if you leave within a 6-month period, or if you leave within a 12-month period, then you'll pay back 50% of the costs. You can't really do that for the license application fee, because like I say, it's not specific to the individual, but you could look to try and recoup some of the costs back.
Okay.
But it's you know, yeah, I think you need to be pretty confident and certain that the individual that you're recruiting is, you know, is the right person, I think.
Yeah.
Because you've got, you know, and it might be that the individual has skills that no one else has. There might be a senior individual, they might just have, like I say, a skill set that they've been looking for a while. So I think it's just important to get to that stage, but that's the recruitment process.
Yeah. Okay. Thanks, Alan.
Yeah, no problem. Any good, Paige, or?
I don't know, is that any better?
It started better, yeah.
God, I'm not really sure what's going on. It might be because I'm connected through my browser. I'll crack on, and if it gets bad, tell me and I can try and dial in again. Yeah, so sponsoring the migrant worker then, once you've got your license in place. So just some, and I think I heard you talking then as I dialed back in about the costs. So in terms of who can apply first, obviously the applicant who you're looking to recruit, but also their dependent partners and children as well. They can apply, and that would, if they had a dependent visa, they would then also have the right to work and live in the UK. In terms of costs, so the certificate I mentioned, hopefully you could hear me when I was talking about it. That's the important document that you need once you've got your license in place, and it includes all the details about the applicant in terms of their personal details, their passport details, the salary, the job role, and that's assigned within the management system once you've got that license in place. And the cost of that, and you pay this cost once you assign the certificate, is £199, and that's an employer cost. So that isn't a cost that you can recoup from the employee. You've then got the individual application fee. These range from sort of £600 to £1,500, and the difference in application fee depends on how long the visa is being applied for. So the lower fee is up to 3 years, the higher fee is over 3 years, but it also depends on where you apply from. So if you apply from inside the UK, it's slightly more. If you apply from outside the UK, it's slightly less. The health surcharge is £624 per year of the visa. And again, you have to pay that when you submit the application online. So if it's a 3-year visa, for example, you pay the full 3 years worth of the health surcharge. So it's not a cost that you pay each year. You pay up front when you do the full visa application. And that is a charge that you can try to recoup from the employee. The skills charge then is payable at the time of assigning the certificate. It's £364 or £1,000 per year. That depends on the size of the organisation, based on what Alan said before, the similar rules. Excuse me. So obviously a smaller or a charitable organisation pays the lower fee, and a medium or large sponsor, they pay the higher fee. And again, that's per year and it's all paid up front. So if it's a 5-year visa and you're a medium or large sponsor, you pay the full 5,000 at the time of assigning the certificate, and that's another employer charge. So that isn't something you can recoup from the employee. There's also sometimes the applicant has to do a visa appointment. Sometimes you have to pay for them. There is a new app that's free to use, but that's only for EU nationals. Otherwise, they have to go to a visa appointment, and these can sometimes have a charge as well. So it just depends on each circumstance. In terms of how long it takes, it's 3 weeks generally for an outside UK application, 8 weeks for an inside UK application. And the processing clock, so these timeframes run from the point at which the applicant has given their biometric details. So that's either through the app or at a visa appointment. There are priority and super priority services. These were suspended for quite a while, mainly over summer from around March time until August this year because of the Ukraine crisis. The UKVI were prioritising family visas for Ukrainian nationals, and to reallocate resource for that, they suspended the priority services. So they're back up and running now, and we've used them for quite a few visas recently. And there's an additional fee. So the priority fee, it again depends where you're applying for, but it's generally a bit lower than the price we've got there on the slide. It's about £250, and that's to get a decision within 5 working days. And then the super priority is around £800, and that's to get a turnaround within sort of 24 hours. So if you're up against timescales, then the option is there to get a quicker outcome. In terms of the immigration routes, then I think Alan mentioned some of them before, and obviously the sponsored routes are the routes that require a sponsor license from the employer and require sponsorship for that employee. So the skilled worker, which is the most common route, the GBM, which obviously used to be the intercompany transfer. Under that, there's now 5 subcategories. So the main one being the senior or specialist worker. Graduate trainees, if you have overseas entities and you want to move graduates around as part of a training program. Service suppliers, secondments and scale up separate, but secondment and service supplier, they're quite new under the GBM. We haven't seen many of those yet. The requirements are quite strict. So for a service supplier, they have to be employed by an overseas entity, and they have to supply services to a UK company, and that contract between the overseas entity that they work for and the UK company that are providing services for has to be under a trade agreement. And then in terms of secondment, if you want to second a worker to a UK partner or a UK firm for learning purposes, there's got to be a contract between the 2 entities up to a value of, I think it's £50 million or 10 million per year. So it's quite a high requirement. So we haven't seen many of those coming through yet. Scale up, that's for new businesses. It's quite a flexible route. It's quite new. Again, we haven't seen any come through yet, but the idea is to open up the international market more to new companies. And then the UK expansion worker is for entities overseas from the UK looking to set up over here. They can get a UK expansion worker license in place, and it's a slight anomaly to what Alan mentioned before in terms of the key personnel, because they can have a sponsor license in place with nobody based in the UK in order to get somebody over to then start setting that up. So it's a slightly unusual one. Again, that's quite new, but it's all part of the sort of government's initiative to open things up more. Non-sponsored routes, obviously not the focus today, but just worth mentioning. As part of sort of recruitment considerations, you might come across, as Alan mentioned, for example, an overseas national on a graduate visa. That doesn't require sponsorship. By virtue of having that graduate visa in place, they have the right to work. They are only in place for 2 years, so they're only valid for 2 years. They can't be extended past that point. So if you do employ somebody on a graduate visa, then obviously as that 2-year expiry comes up, you'd have to consider sort of other routes. So the skilled worker, for example, family, as I mentioned, dependents, so spouses or dependent children by virtue of that family or spousal visa, they have the right to work. The settlement scheme, again, if somebody has settled or pre-settled status in the UK because they lived here before the 31st of December 2020, they should have applied through the EU settlement scheme to obtain that status. And again, even though they're overseas nationals, if they have pre-settled or settled status, then they have the right to work. So it's just worth considering those various different routes. So when we're looking at the points-based visas then, and like I said, we're focusing on skilled worker and senior specialist worker. But these validity requirements, they apply to the different various routes. So similar to the sponsor license, there's an online application form to complete. It's worth mentioning that you obviously have to click through the correct link. Sounds like it might be an obvious point, but for example, if you're switching to a skilled worker or if you're applying for a skilled worker outside the UK, you have to go through the correct government website page and the correct link. Completely online form. They're fairly straightforward. It includes all the applicant's personal details about the role, their travel history, for example, any refusals that they've had in the past or any breaches of previous immigration rules. That all has to be included on the form. As I say, when you submit the form, you have to have paid the immigration health surcharge for the visa application to be valid. And the applicant must have also provided their biometrics and ID document. So ID document tends to be the passport. If they're applying from, what we see quite a lot of is clients in the US, they have a worker in the US that they want to transfer to the UK under the intra-company transfer or the GBM route, but that applicant is actually from another nationality, so it could be India, for example, or wherever that might be. They also have to show that they have the required permission to be in the country that they're applying from. So these are the sorts of documents that we would be asking for if we're supporting a client, and that would be submitted alongside the application. And then the biometrics, that's fingerprints and photo ID. So that can be, if it's outside the UK and the EU, that would be a visa appointment. And generally the applicant would have to send off their passport for the duration of the processing time, and they'd get that back with a stamp in it. Or if they're an EU national, then they do have the option to use the app, which streamlines things slightly. It obviously eliminates the need to go to an appointment. It's free, and it does seem to work quite well. So the application, it can't be submitted more than 3 months before the intended start date. So it's useful well, it's important actually to keep that in mind, because if you submit it too early, then it would be invalid. And then some specific countries, a TB test and proof of that is required alongside the application form. And if you do have somebody who's switching in country, so for example, somebody on a graduate visa that you've employed for a year, and that graduate visa is coming to an end, and they're looking to switch to a skilled worker, for example, then they can do that. There's no cooling off period. There's no requirement to leave the country and re-enter, for example. But the categories that we've got on the slide there are categories that you can't switch in country. So if somebody's here as a visitor, for example, they'd have to leave the UK to then reapply. So that's pretty much what needs to be in place for the actual visa to be valid. So I mentioned points-based, and it is a points-based system now. So we've got on the slide there just a short comparison of the skilled worker route and the senior and specialist worker route. So you'll see for the skilled workers, the requirement is 70 points, and that's made up of 50 mandatory points and 20 tradable. And for the senior or specialist worker, it's 60 points and they're all mandatory. And we'll look at each eligibility requirement in more detail. So the sponsor then, so the first set of points for both routes is 20 mandatory points for the sponsor. And this means that obviously the employer has to have a sponsor license in place. They have to have issued a valid certificate of sponsorship. So as I mentioned, that's an important document. The applicant can't make the visa application, so they can't do the online form until they have that certificate of sponsor, because there's a unique sponsor reference number on there that's unique to their application that they need to put on the form. They have to be a licensed sponsor, so they have to obviously have the license in place but be A-rated. They obviously have to have paid the immigration skills charge that I mentioned, and that's obviously paid at the time of assigning the certificate. And then the genuine vacancy that Alan mentioned before. So again, it's just part of that pre-application preparation. You know, if there is an audit or if the Home Office don't, can you come around? If they come around, can you show that their job does exist? You know, it's not a sham. It's not been created solely for the purpose of you know, gaining entry leave for that applicant. So there has to be a genuine vacancy. And usually what we will ask for to support that is evidence of a draft employment contract or a job description. Things like that are always useful to submit, and they're not mandatory documents, but we always like to submit as much as we can to support the application, as we would for the sponsor license. The more that we can send, the better, really. And then just checking who the sponsor is. So if somebody's being sponsored by an organisation to supply labour to another organisation, a third party, then the Home Office are going to want to make sure that the sponsor is correct, that the person acting as the sponsor, the employer, does actually have full responsibility for the duties, the functions, the outcomes, the outputs of the job, as you know, a normal employer would, and that they're not obtaining the visa to then go and essentially work for somebody who isn't sponsored. So that would be 20 points. The next set of mandatory points is having a job at the appropriate skill level. So Alan mentioned before the SOC codes, and you can type in on Google skilled worker SOC codes or senior specialist worker SOC codes, and you'll get quite an extensive list of different occupation codes that can apply. The skill level for the skilled worker route is A level or above, and for a senior or specialist worker, the two lists are slightly different because it's a slightly higher skill level, and that's graduate level or above. It's important to get this bit right. As Alan mentioned, they could come back with questions if the caseworkers you know, processing the application think that the SOC code has been exaggerated, or if they think an incorrect code has been applied. In some situations, you might be given the flexibility to correct it. And like I say, it's a very long list. A lot of them do overlap. So if it's the case that the caseworker thinks it's an innocent mistake, then you know, you'll be given the opportunity to correct that. And similar to the sponsor license, if you do get requests for further information or further clarity from the UKVI when you're doing a visa application, then it's important to respond promptly and fully to avoid any delays or you know, worst case scenario, refusals of the application. The last point to mention on that slide is the ATAS requirements. That is more for sort of research roles. The sponsor has to be a work sponsor that's licensed as a student sponsor as well. And this is mainly for roles that include an element of research at PhD level. So it's not a common requirement, but it's just worth bearing in mind if it does apply to your organisation. So for the skilled worker route then, there's an extra 10 points mandatory requirement for the English language level. This isn't a requirement for the global business mobility route, but it is for the skilled worker. And again, we get a lot of questions on this when we're assisting clients with skilled worker applications. It's mandatory. You have to prove your English language level to the 4 components. So that's reading, writing, speaking, and listening / understanding. And you can show it in a number of different ways. So you can do a secured English language test. And the government website has a useful page where they set out the various approved providers that you can use, both inside and outside the UK. And this applies for skilled workers applying from inside the UK as well. So even if there's an individual who's already here on a graduate visa, for example, looking to switch to a skilled worker, they would still need to prove their English language level when making that application. So you can pass a SELT test. You can rely on a qualification. So if the applicant has a GCSE, A level, level 4 or 5 Scottish Higher, for example, that they was taught at a UK school before they turned 18, then they can rely on that. Or equally, if they have a degree level qualification that was taught in English, even if that was at an overseas university, for example, in their home country, or a master's, for example, then again, they can rely on that. And what they would have to do is apply through something called ECTIS, which was formerly referred to as UK NARIC. You might have heard that referred to as that before, but you apply through ECTIS online. And to do that, you have to send a copy of your transcript, your degree certificate, a letter from the university to confirm that the module or the qualification was taught in English. And then what you'll get is a certificate from ECTIS to confirm that, 1, the qualification is reflected in UK level, so it does match that degree level or above, and then 2, that it was taught in English, and it was taught in English to the level of B1 or above, which is on the it's the Common European Framework, which sets out the levels, and it has to be B1 or above for a skilled worker, which is I think it's competent. And it is quite confusing because you'd think A would be the top, but A is actually the lower level. So there's A1 and A2, B1 and B2 are sort of the middle band, and then C1 and C2 are the top level, and it's B1. So it's a relatively low level, but again, that definitely has to be met for a skilled worker visa to be valid. It doesn't apply though if you're applying from an overseas country that speaks English. So there's a list on the government website again that sets out excluded countries that people are applying from. They don't need to prove that, and what they'll do in the application is obviously state where they're applying from, and that's sort of automatically applied, and the requirement to show it doesn't exist in that case. So that's just for skilled workers, and that's 10 points. So for both the GBM, the senior specialist route, and the skilled worker route, there's a further 20 mandatory points for salary level. So for the senior or specialist worker route, the threshold is 42,400, or the going rate for the role, and you can find the going rates for each SOC code on the government website. And that's the general requirement. There's no sort of tradable element to that. That is the minimum that the applicant can be earning when they're in the UK. But this is where the tradable element comes in for the skilled worker route. So because it's a slightly lower skilled route, I guess, there's sort of various options that you can do to make up these 20 points. So the general option is the minimum salary threshold, which for skilled workers is 25,600, £10.10 an hour, or the going rate. Or alternatively, they can be paid less, and I've listed there's 6 different options. So for example, if they've got a relevant PhD, they can be paid slightly less at £23,040, £10.10 an hour, or 90% of the going rate. If they have a PhD in a STEM subject, they can be paid even less, so 20,480, or 80% of the going rate. Again, if their job is on the shortage occupation list, they can be paid less. If they're a new entrant, they can be paid less. And a new entrant is an applicant who is new to the labour market, so they have to be aged under 26. And And again, if they're in a job that's listed as a health or education occupation, then they can be paid less as well. So this is part of the assessment that we will help clients with when we're sort of preparing for the visa application. We'll look at the salary, we'll look at the role, and we'll consider how we make up and meet those eligibility criteria. So settlement and overseas working requirements. So obviously it's a bit of a tick box exercise to make sure that we meet those validity requirements, suitability and eligibility requirements. But when considering the best route to employ an applicant from overseas under, there's other sort of factors that feed into it. And one question we'll always ask is, what's the applicant's plan? What are they looking to do here? Are they looking to settle? Are they looking to, you know, permanently come and live in the UK? Because if they are, then you know, the skilled worker route is probably going to be more relevant for them, because that route leads to settlement. The senior or specialist worker or any other route under the global business mobility doesn't. So what that means is time spent in the UK under a skilled worker visa can count towards settlement. And to apply for settlement in the UK, you've got to have lived in the UK for 5 continuous years. So you can apply each time for a skilled worker visa for up to 5 years. So for example, if your organisation looks to employ somebody under a skilled worker visa for 5 years, you pay all the costs, you have the visa in place, they get to that 5-year point, an option for them then would be to consider applying for settlement rather than extending the visa, for example. The other requirement for the global business mobility, the former intracompany transfer, that doesn't apply to settlement is, doesn't apply to the skilled worker route, is the overseas working. So in addition to the other salary and job requirements, for a senior or specialist worker, they have to have worked in an overseas entity, and that entity is obviously part of the group of companies. So when we talk about the intracompany transfer, it's obviously intracompany from overseas. So for a senior or specialist worker, they have to have worked for their overseas entity for 12 months or more, unless they're earning over 73,900, in which case there's no minimum overseas working. And like I say, for the skilled worker route, there's no requirement for the overseas working. So the last sort of requirement then, and like I say, this applies to both skilled worker and the intracompany / GBM route, but also to other routes. So the dependents, for example, also have to show financial means, is the financial requirement. So this can be met in a couple of different ways, but essentially what an applicant needs to show when they're applying for permission to come to the UK is that they have financial means to maintain themselves for the first month at least whilst they're in the UK. A lot of the time, most of these visas are granted, and the conditions on the visa are that they can't access public funds. So it's a condition that they have to be able to show that they can maintain themselves. So the requirement is that they have to be able to show that for the first month in the UK, they've got £1,270 available, and that has to have been available for 28 days prior to submission of the application. And there's a couple of ways they can show that. So if they've already been in the UK for at least 12 months, so for example, go back to the graduate visa, they've been here for 2 years on a graduate visa, and they're now at the point of making the application for a skilled worker. They've already been in the UK for at least 12 months. They don't have to show the financial requirement. But otherwise, if the applicant hasn't been in the UK for 12 months, then they either have to show proof, so for example, pay slips, bank statements, of having £1,270 available, and like I say, having it available for 28 days before the application. Or alternatively, the sponsor can certify maintenance. So when you go to assign the certificate of sponsorship in the management system, one of the last questions on the form is, do you tick to certify maintenance for the applicant? And what this essentially means is if there's any living costs or anything that the applicant needs to maintain themselves for the first month, the sponsor is essentially, you know, given an undertaking that they will do that. They're certifying that. They're saying to the Home Office, you know, we will provide for that employee if needed. And we generally recommend, if they can, that sponsors do tick that. You know, the chances of somebody not having the funds is very unlikely. And it does make the application process a lot easier for the individual because they don't have to show proof of, you know, having the funds. So that's just one other thing to consider. In terms of the process then, I won't go into too much detail. It's very similar to the sponsor license, but as I say, the certificate of sponsorship is really important. You have to assign one to each migrant worker that you want to employ. It's electronic, so it isn't a physical document. Like I say, you get it online in the management system once you have your license in place. And each certificate has a unique number, which the applicant then inputs into their online application form. Once that certificate has been assigned to an individual, they have 3 months to use it. So that it's valid for 3 months. But that's a separate 3 months to the application date. So it's almost step by step. So you assign the certificate, that certificate is valid for 3 months. So the applicant has to use that certificate in a valid application before that certificate expires. But then equally, that application can't be submitted 3 months before the start date. So as part of the pre-planning that Alan mentioned, similar to the sponsor license, for a visa application, it's important to sort of get timescales right and have that 3 months in mind. There's 2 different types of certificate, and this is a question we get asked a lot from clients when they're dealing with certificates, is which one to use. So there's defined certificates and there's undefined certificates. Defined certificates are for applicants applying outside the UK as a skilled worker. And then undefined are for skilled workers applying inside the UK and all other applicants. So when you apply for your sponsor license, one of the questions you'll be asked is how many people do you sort of envisage that you'll be employing under the license, and you'll give an estimate number. And again, that forms part of the pre-planning for the sponsor license, having in mind how many certificates you might need in any 1 year. And what you'll get once you get the license in place is an annual allocation. So for example, if you say you might need 4 undefined certificates, and it's only undefined certificates that you can be allocated. So just say you envisage employing, for example, 2 people from an overseas entity within the sponsor group, and potentially 2 people from within the UK who are on different routes, but you want to employ them as skilled workers, so you'd need the undefined. Then you'll be given an annual allocation of 4 undefined certificates, which you can then use. And if you need to apply for more, you can. But you'll have 4 almost, you know, ready and waiting to assign in circumstances where they're on any other route other than skilled worker or applying inside the UK as a skilled worker. But then the defined certificates you have to apply for on an individual basis, and it's free to do. They generally turn them around within sort of a day or 2, but because they're coming from outside the UK as a skilled worker, you need that defined certificate and you have to apply for that in advance. So again, it's worth just keeping that in mind as sort of part of the timescales when you're preparing for the visa application, because it can take a couple of days to get the defined certificate, but it's quite an easy process to do. The level 1 user has to do that within the management system. And as Alan said, there's loads of guidance on the government website. On Google, there's manuals that help the level 1 user. So anything that a level 1 user or a key contact or the authorising officer needs to do within the license, there's a manual for that as a step-by-step with pictures as well, so they're quite useful. So that's the certificate. So once that's been assigned, as I say, there'll be a unique number that the individual has to put in on the online application form. Once that's all completed and they're happy with it, they submit the online form, pay the health surcharge and pay the application fee. They'll also have to send off any supporting documents And there's a couple of ways to do this. So if you use the UKVI app, you can upload them through the app. But the app can also be used in a sort of a web browser. So when we're assisting clients with this, and the applicant wants to use the app, they'll use it on a smartphone to provide the biometrics and passport information. We will then be able to log in online and upload the documents for them, or they can do it themselves. It is quite easy to do. The other way to do it, if they're not using the app, is at a visa appointment. You get the link to book the visa appointment after the application form has been submitted, and through that link you book your visa appointment, but you also get the opportunity to upload your supporting documents. And it's really important to do this before the visa appointment. Generally what we're seeing at the moment, and again it depends where the applicant's applying from, but it can be sort of a week to 2 weeks wait to get a visa appointment at the moment. So again, it's just worth bearing that in mind for timescales. But you can pay for priority services, like I said before. Some of them are free, sometimes there's a cost. It all just factors into how quickly you need it. But that's the supporting documents. And as I say before, the sort of documents that we would expect to see would be obviously the certificate of sponsorship, proof of the role, so contracts, any job descriptions. If maintenance isn't being certified, then obviously financial documents to show that they have the means to support themselves, proof of ID, so like I say, that would be the passport, proof of permission to be in the country they're applying from if it isn't their home country, and obviously for the skilled worker route it would be proof of the English language level, so that might be the ECTIS certificate, or it might be certificates from the English language test that they've taken. So once we've uploaded supporting documents, obviously you have the visa appointment, as I say, either the app or in person, and then it's a case of waiting for the decision. So I think I mentioned before the timescales, the processing clock will only start to run once the applicant has either uploaded their documents and biometrics to the app, or once they've attended their visa appointment. So again, it's just worth bearing that in mind when we're looking at timescales, because if you submit the online form and you've then got a couple of weeks to wait to get the biometrics appointment, that 3-week or 8-week processing clock will only run from the date of the appointment. But obviously there's the priority services as well that are now back up and running if you need that. So that's a bit of a whistle-stop tour through the process. Before we have a quick comfort break and then move on to the last part, does anybody have any questions on any of the visa side of things? No? Perfect. Hopefully you could hear me better then.
Can I ask a question?
Of course, yeah.
Yeah. Obviously I've got a sponsor license and obviously I've applied. We identified 2 people that we wanted to employ here in the UK, and we've been turned down both times. And we thought that we had all the criteria, and but the decision, it took them a long time to decide. We thought that we were going to get notification within 2 days. For applying for the defined certificate of sponsorship, but it actually took 8 weeks for them to come back. But I believe at that point the Home Office were struggling for staff.
Right, so it was the defined certificate application that was the cause of the delay, was it? Took 8 weeks to get that. Right, and did they? And when you say it was refused, did they give any reason as to why they refused that?
Well, they were questioning why we were charging for the accommodation.
Was that included in the salary?
Yes.
Okay, I think when they ask for so when you apply for defined certificate, it's defined because when you have an annual allocation of undefined, they can obviously be assigned to anybody, but defined certificates are defined to that individual. So as you'll have seen when you made the application, you obviously have to put in the personal details, but also the job details when you apply for that. And in terms of the salary, I guess it's basic salary, and any allowances for relocation or housing, there's a separate box to put that in. Did you split it up like that, or was it all included in sort of the full salary amount?
We did split it up because we were getting some advice as to what to do, and we did split it up, but they refused it. So to date, we've had the sponsor license for almost a year now, and we've not been able to bring anybody across to the UK.
And does the salary level meet the thresholds we mentioned in terms of the going rate and the minimum general threshold?
Yeah, we were actually offering more than the minimum.
That does seem unusual. I mean, I can't see why they would refuse that if the sort of criteria we've mentioned have been met. Have you tried again since?
We've kind of been a bit disillusioned by it, and because we tried twice and turned down both times, but both with different reasons, and yeah, it's kind of disillusioned us. We still have obviously we're based in Keswick, so we have a big problem trying to recruit. There's just nobody wants to work, in the Lake District, unfortunately. All the businesses in Keswick we're all struggling.
I guess I'm just trying to understand why, like the reason for it, because if you're saying it was to do with allowances or accommodation, really as long as the salary threshold was met, then that shouldn't really be too much of an issue. I mean, they might have concerns about where the individual is living, but I don't really think that's covered in the certificate. Obviously, when you apply for the certificate, it's not really there. The certificate's only really wanting to know, are you a sponsor? Which you are, because that's why you're applying for a certificate, and then details about the salary and the role. So what's the SOC code for the role and what's the salary, and as long as the salary was above the minimum threshold for the role slash the 25,000 or whatever the minimum threshold is for the SOC code, then I can't see really why they would refuse it on the basis. I mean, I guess the only thing you could do is you could contact us separately and ping over exactly the details you put into the certificate request for the defined certificate, and we could see where they might have rejected it. But I can't really understand where it would be. So it was a skilled job. It was at the required skill level, and it was at the required salary threshold.
It was actually over the.
It was over. Yes, it was above.
It was above.
The only thing I can think is if it wasn't in line with the going rate, but the going rate generally is not too much higher than the general threshold. I mean, like Alan said, and Joe mentioned at the start, if you would like us to look at it in more detail, then obviously come be better offering the 1 hour session with us, so we could follow that up and take a look at the documents for you.
Because I mean, I assume you've got the right route as well. Your sponsor license. Have you got the right route? If you had a GMB route, and not a skilled worker route, and you were looking for a defined certificate on the skilled, I don't know really. It's just trying to understand. I mean, what was the second reason for refusal? Did they give the second time? Was it the same reason or?
Very similar. They were questioning why we were going to take money off their salary for all the fees that we were going to have to pay.
Would that have taken it below the salary threshold?
It didn't. It
Right,
didn't
okay.
take it below the salary threshold, and the girl that we wanted to bring across, she's actually got a degree.
Right,
In fact,
okay.
she's got a master's degree, and she does work in. She was coming from Thailand, and she does work in Thailand. But obviously, the money that they can earn over in Thailand, even though they've got a master's degree, is not like what they can earn over here.
Yeah,
in the
and
UK.
your issue is you couldn't when you applied for the defined certificate, you got rejected, so you couldn't have one to assign, and therefore she couldn't apply for a visa.
Correct.
Yeah, I guess that the one thing I think to try and get to the bottom of it is we generally have like a template form that we fill in when we look to apply for defined certificates. I guess the best way to probably deal with it would be to include in that form the exact information you put in your application, and then we would look to see where it's fallen down, if at all. You know, we might look at it and go, then there's nothing wrong, and if that's the case, then it might be that you know it needs to be that we need to contact the Home Office directly and say we don't understand why this has been refused all the time. We've met all the eligibility requirements. It doesn't make any sense, and that's where we would probably want to try and speak to, you know, our contacts at the Home Office to try and get that pushed through. If there's nothing wrong with it, you know, if there's something wrong with it, then obviously you rectify that and you resubmit. But it's probably the best way to try and deal with it.
Yeah, I appreciate it. We, as I say, we've kind of gave up too quickly, but we still have a big problem with recruitment. 2022 has just been the same as 2021 for us, in that we've struggled all year.
Yeah.
Which is where things like this, you don't, you know, if you're getting shut down by the Home Office and there's nothing wrong with the application, it does make you scratch your head. But I guess, you know, let's just have a look at that to see if there's an easy fix, because if there's an easy fix, then it might give you another avenue to then recruit.
Yeah, because we've looked at all the other avenues of trying to recruit locally, and there isn't anybody. And Premier Inn's about to open up. They're pretty near us, and they've got the same problem. They can't recruit either, so it's a common problem, unfortunately.
Yeah, it's the cost of the lakes as well, isn't it, and living and things that makes it tricky. Well, we can certainly look into that for you. Like Alan said, hopefully there's an easy fix, but I think if we can take a look at the documents, that would be helpful.
Yeah, well, when I didn't realise that there was local immigration specialists. It was only when we got information from the local enterprise partnership that we discovered that there's local immigration specialists.
We'll find a way through it. I think we just need to see what information's been put in so far to see where the issue is.
Yeah,
but I can't imagine there'll be a way through it. If the job is a skilled job on the SOC code, is paid at the right level, there'll be a way through it, definitely.
Brilliant. Thank you.
Perfect. Are there any other questions before we have a quick 5-minute break and then come back for the last section? No. Should we come back at about 5 to then? I'm conscious the session's till 12:30, so we don't want to keep you any longer. But we've just got the prevention of illegal working section to run through, and then again we can have a discussion on that after. So if we give it 5 minutes and then regroup.
Sounds good.
Perfect.
Yeah.
Do we have everyone back? We're just waiting for Ian.
Yeah, I think so.
Great. I think that's everyone back. So we'll make a start. We did have some sort of case studies to have a group discussion on, but I think given time, and it'd be useful to just dive straight into this last section. I think Alan mentioned before it's quite an important one, and it's almost the final steps once you have that overseas worker in place, what you need to do in terms of right to work checks. So I'll pass over to Alan, who's going to go through the right to work checks process, and then I'm going to come in and talk about how to prevent discrimination, and then we'll open it up to questions again.
Thanks, Paige. And we'll just quickly run through this over the next sort of 10-15 minutes, and then we'll have some time at the end for questions, I think, because I mean, it is an important area, but it's there's been quite a lot of changes, and I think it's just useful to try and flag what those changes are. And it's important because, you know, right to work checks, prevention of illegal working, it's just important to get it right to avoid any issues that result off the back of it. So the first thing I'd just like to quickly mention is the legal requirements around right to work checks, and you'll probably all be aware of this, so I'll kind of just I'll quickly skip through this, but it's so obviously you need to ensure when you employ anyone, so not just overseas nationals, so British nationals, anyone really that's an employee of your organization, you need to check that they have the right to work, and that right to work has to be carried out before their employment commences. So I guess you could do it on the day of, as long as it's, you know, before they actually start. So if if they were starting at 9, you could do it at 8:30, but really you want to be doing it in advance to prevent any issues around it. So right to work check carried out before their employment starts. If an employee has a time limited right to work, so if the goes back to that example I mentioned, an individual that's got a visa for 3 years, then you have to do the right to work check, but you have to then do another one in 3 years' time when they've applied to extend their permission, or they've applied to switch to a different type of permission. You've got to keep records of all checks, of when checks carried out and when they were taken, and you're not allowed, and this is an important point as well, but you're not allowed to employ anyone where you have or you could have reasonable cause to believe they're an illegal worker. So even if they provide you with a valid, or what looks on the face of it to be a valid right to work check, if for whatever reason you know that they don't have the right to be in the UK, then you can't just hide behind that document. So it's an important point, that, and you may not have reasonable cause, you may never be in that position, but if you were, then as I say, you can't just hide behind the document. You can't employ in that situation. And as long as you follow those basic principles, the whole purpose of doing it is to get something called a statutory excuse against a civil penalty. And that basically, so if you follow the right to work check guidance on the Home Office website correctly, you do the things I've just mentioned, obviously in a bit more detail, which I'll come on to in a second. But like I say, that will give you a statutory excuse. So if the Home Office ever came to you and said, this individual doesn't have the right to work, you can then reply and say, well, we carried out all the steps, we followed the guidance, here's our statutory excuse. And as I say, it'll prevent you, or give you a defence against a civil penalty. And the important, as I mentioned, the reason for doing it correctly is to avoid any potential sanctions, and those sanctions could be a civil penalty of up to £20,000 per legal worker. It's quite a big, you know, if you did this on a number of individuals, it'd be quite a big amount. A criminal conviction, so that's the one that everyone's always a bit very cautious of, which attracts a sentence of up to 5 years or an unlimited fine. And then if you've got a sponsor license in place, then the risk of that being revoked or downgraded. So that's the sort of basic principles around it. So page on the next slide, in terms of the types of checks. So there's been a few changes recently around, you know, I think back in the day, it was all about a manual check. So, you know, you obtained the document, you checked it in front of in the presence of the person, and you took a copy of it. That was generally how we used to do it previously. But now there's various routes. So there's you can obviously still do a manual check. So meeting the individual in person, get the relevant document from list A or list B, and then taking a copy. So that's one option. Second option is you could do an online check, which has just come in over the last couple of years, which involves using the Home Office online check-in service and obtaining something called a share code from the individual to check that they've got the right to work. And then the new route, which has just come in over the last sort of 6 months, is a digital check. So you can use something called, and it's a bit of a mouthful, but Identity Document Validation Technology, or IDVT for short, which is basically using a provider, a registered provider, to carry out that type of check. And that's only available for checks on British and Irish citizens. So it's quite limited. That might widen over, you know, in time, but at this moment in time, it's only on British and Irish citizens that you can do a digital check. And on the slide that Paige has just pulled up there, you need to do certain checks on certain types of individuals. So it's not as if you can just say, right, well, we've got these 3 options, we can use any one. They are specific for different categories of people. So for someone that's got a biometric resident permit or biometric resident card, which is generally most people that have got skilled worker visas or the global business mobility route, so anyone really with a visa under those types of routes, they would have a BRP. And it's mandatory to do the online check for those individuals. So if you decided, you know what, we're just going to obtain a copy of their BRP card, their little pink visa card, we're not going to do an online check, then that wouldn't provide you with a statutory excuse, because that's not what the rules allow. So, and then similar with people with digital status or e-visas. So by that, the easy example is someone with settled or pre-settled status. Those can only be done online as well. So you've got to make sure that when you do the check, you use the appropriate method. And I guess, you know, for anyone that doesn't fall within those categories mentioned on that slide, you know, British and Irish passport holders, for example, or those with a visa affixed to their passport, those checks can be carried out manually or via this digital technology. So that's a general kind of overview of the different types of checks. So on the next slide, in terms of an online check, so those steps that are on the slide, so obtaining a share code, checking, retaining, step 1, step 2, step 3, that's basically what you need to do to carry out a valid online right to work check. And like I say, you need to do it properly to make sure you get this statutory excuse against a civil penalty. So the main takeaway is that if you do an online check, you have to basically ask the individual to provide you with something called a share code. So they'll go onto their own portal, their own individual portal, obtain something called a share code, which will then get sent to you as the employer. You as the employer then go onto the specific page on the government website, which is on the slide, and then you type in the share code, put in the individual's date of birth, and then it brings up their profile page. So it'll bring up their profile page with a picture of their photograph, and it'll say whether they have the right to work in the UK and whether there's any restrictions on their ability to write to work in the UK, including like time limitations and what type of work they can do. So that's the main thing you're looking for. And what the Home Office asks you to do is basically check that profile picture matches the person you're about to employ. So you've got to basically validate that it is the individual and it's not like an imposter or something like that. So so then when you've done that, there's a little bit on the profile page that allows you to print it off as a PDF. So you then have to print it off as a PDF and save that PDF in your HR, file systems, personnel files, and you need to keep a copy of that for the duration of the employment and for 2 years after. So if the Home Office ever did an on-site check and said, show us all of your right to work checks, you can then pull up that information for them. So that's kind of a bit of an overview on the online right to work check. On the next slide page, we've got like the manual right to work check. So that, again, similar in terms of step 1, step 2, step 3, but different in terms of the process. So like we did back in the day, you have to obtain original documents from list A or list B. So there's a whole load of documents which are classed as eligible documents. And if you're not sure, the Home Office has got a sort of an app, an interactive tool where you can go through, answer a few questions, and it'll tell you what type of document you will need, which I think is useful. But once you've identified the right document that you need, you've then got to carry out various checks to basically make sure, well, that the document's valid, genuine, not a fake, basically, and that the document demonstrates that the individual has the right to work. So checking photographs and date of birth so are consistent with the person's appearance, checking for expiry dates, because that might then mean that you have to do another right to work check when the dates expire, or the passport, for example, or not a passport, a visa might have already expired, so someone might be presenting you with an expired documents which you wouldn't be able to use. Check for any work restrictions, like I mentioned before, and I think it's probably important to flag that with students. So students, when they're carrying out their course, can do work during their course, but they are limited to a certain number of hours. So they're limited to generally around about 20 hours during term time. So you've got to make sure that you obtain and retain copies of like any academic term and vacation times covering the period of study. So it's so there's various things you have to do depending on the type of individual you're looking to employ. And then the other thing, you're making sure the document is genuine and not tampered with, which is quite hard. But you've got there's various information on the government website which tells you how to be able to identify a fraud document, which would be useful to look at if you were ever in any doubt. And then sometimes you might have a situation where someone's changed their name through marriage or divorce, and the name of the individual is different to the document that's been presented. So in that situation, you'd probably have to obtain additional documents like marriage certificates or deed polls or some, an additional document to link up the name changes. So, and then once you've done all that, similar to the online check, you need to make sure you've got a clear copy of the document, which can't be manually altered. You've got to keep that document secure electronically or in hard copy. You've got to record the date on which the check was made, so you can show to the Home Office if they ever looked at it when the check was done. And then you've got to, as I say, you've got to retain copies of the documents. And what I mean by that is, with passports, you've got to copy any of the pages which has things like the expiry date, nationality, date of birth, any signature, biometric details, things like that. That part of the passport has to be copied and retained. You don't have to copy the front cover. You used to have to, but you don't have to anymore. And then with all other documents, you need to do copy the whole document. So like both sides of an immigration document, for example. And like the online check, you've got to keep that securely for the duration of the employment and for 2 years after. And then after that 2-year period, it has to be destroyed for GDPR reasons. In terms of digital checks, so that these came in 6 months ago, and I'll not touch too much on this because they are quite restricted in terms of British and Irish citizens. But what I would say is, if you were going to go down this the line of using this, you have to then identify, you have to use an IDVT provider who can carry out remote checks, and that's the purpose of it. With the pandemic and things like that, these allow employers to carry out remote checks via a provider. There's an additional cost to do it, so it's not free. The IDVT provider sets the charge, which is putting obviously a lot of employers off because they're thinking, well, we can just do a manual check. But like I say, it depends if it's remote working, and doing a manual check is actually easy to do because you have to do it, in the presence of the person. If you do use this route and you identify a provider, the Home Office says that it has to be a medium level of confidence as a minimum standard. So these providers will have this linked to their organization, so you have to make sure it fits within that. And even if you do use this IDVT provider, it's still your responsibility as the employer to carry out your own due diligence. And what I mean by that is to make sure that IDVT provider has carried out the check in the prescribed manner. So they'll provide you with a document which you'll then check matches the person you're about to employ, but you need to make sure it's all been done correctly still. And then again, you need to retain a copy of that check for the same period, so employment and then 2 years after. And then the only other point I just want to quickly mention, because that's a kind of overview of how to do the right to work checks. The only other point I just want to mention, which comes up quite a lot, is what happens if someone comes to you that doesn't have a valid document. So you might have an individual that says, look, I did have a visa, but that visa expired. I've applied to renew my visa, but I'm still waiting for a decision from the Home Office. So I can't provide you with a valid document now, but trust me, I've got a document that's waiting a decision. So in that situation, you could potentially still employ them, but you have to do something a bit different. You have to use the employer checking service, which is free, but you've got to, with the consent of the individual, you've got to basically provide certain information, including maybe an application reference number that they've got, their details, and then that'll go through to the Home Office, and then they'll come back to you and confirm whether the individual's got the right to work. And if they do, they'll provide you with something called a positive verification notice, and that will basically say, look, this individual's got a pending application that's with us at the moment. You will have a statutory excuse to employ this individual for the next 6 months, and that's ultimately what you need. And as long as you keep a copy of that positive verification notice, that will provide you with that statutory excuse, and the individual can continue working under their old visa until a decision is made on their new application. So that's generally, it's called something called Section 3C leave is what they're protected by, but that's kind of one way of doing it. So just because an individual can't present you with a right to work document, that doesn't mean it's game over. It just means that you might have to start thinking about using the employer checking service. And the last thing I would say is, worst case scenario, the Home Office comes back and says, no, they don't have the right to work. They didn't submit an application. You'll then get something called a negative verification notice. And in that situation, that's when you start thinking alarm bells, we need to seek legal advice. We might not be able to employ this individual. So that's all I really wanted to say on that kind of area. And I think Paige is going to talk about recruitment and discrimination issues.
Brilliant. Thanks, Alan. So I'll touch on this quickly, but I think it's just useful to bear in mind when we're looking at these issues, just keeping in mind the discrimination angle on things, because race and nationality is a protected characteristic under the Equality Act. So I guess in terms of the recruitment process itself, there's a useful guide from the Home Office that was updated in April this year, that sets out sort of the expectations and guidance for avoiding discrimination during the recruitment process. I guess the main points to sort of bear in mind with it are that employers shouldn't have policies or processes or practices in place that directly or indirectly discriminate applicants on the basis of their race or nationality. And there's quite a famous case which you've got on the slide there. Osborne Clark is a law firm, and they had a policy of not accepting applicants for training contracts from non-EU nationals who required work permits. And it went to appeal tribunal, and the appeal tribunal held that employers shouldn't have that practice in place. So employers shouldn't be preventing individuals from applying for a job because they don't have the right to work. The recruitment process, the selection process should all be based on merit, and any issues relating to right to work should be considered, at the end of the recruitment process. So, not until the offer stage, for example. And that means treating everyone fairly. So everybody's, on the same page, everybody's treated fairly throughout the recruitment process. And any issues of, right to work are only considered right at the end once an offer's been made based on merit. In terms of sponsorship, obviously, if an employee is a registered sponsor, then a job applicant might have an expectation that the employer would sponsor them. And even if the employer isn't the sponsor, then they might still expect the employer to go off and get a license in order to be able to sponsor them. And sometimes, if applicants are rejected on the basis that the employer doesn't want to sponsor them, there isn't a legal obligation on employers to get a sponsor license. There isn't a legal obligation on employers to sponsor individuals or to sponsor a particular individual. However, if we're looking at this through the lens of discrimination and somebody brings a claim for discrimination on the basis that a prospective employer didn't agree to sponsor them, then they'd have to objectively justify that decision not to do that. And there's a case, a recent case that demonstrates that in order to justify that treatment, there's got to be a reason above costs alone. And it refers to a cost plus approach. So there's got to be more of a reason than just costs to justify not sponsoring that person. So for example, if somebody else was offered the job based on merit and you're able to show that, or for example, if the role doesn't meet the suitability or the eligibility criteria that we talked about before for the visa. So for example, the salary doesn't meet the threshold, it doesn't meet the skill level, it doesn't meet a SOC code, for example, then that might be enough to justify not sponsoring them. But generally it has to be more than cost alone. So that's the recruitment process. I guess in terms of the actual offer, offers of employment should always be made conditional on the employee having the right to work. As Alan's just mentioned, they've got to do the right to work check and prove their right to work before they start their employment. And you as the employer, your organisation has to have the ability to withdraw that offer if the individual can't show their right to work. Otherwise, you fall foul of potentially employing illegal workers. So always have that in mind when giving out offers of employment. Final slide then. If you are faced with the situation where you have a prospective employee or even a current employee who had a time limited permission to be in the UK that's coming towards an end, and you have to do an updated right to work check, and you have an employee who can't demonstrate their right to work, it's a tricky area, it's a sensitive area, it's one to manage quite carefully, and we would always say to seek legal advice. But I guess the main risk or concern with it would be potential unfair dismissal claims. So I think the first thing you would need to do if you're in that situation would be to investigate and do that promptly. So quickly investigate the matter, speak to the employee about their immigration status, because it might be, as Alan mentioned, that they have made another application and it's a valid in-time application and they're waiting to get a decision, in which case they would be protected by that Section 3C leave, which would extend their right to work, and which, to dismiss them would be unfair, it would be unlawful. So investigate, speak to the employee, and you'd also be expected to use that employer check-in service that Alan mentioned. So if you're in the situation where you're having to do this, consult with the employer check-in service. If you get that positive notification, then that would give you a statutory excuse for 6 months to continue to employ them. But obviously, if you get a negative notice or you have grounds to believe that they haven't made a new application, you get the negative notice from the Home Office and they have no other way of showing you that they have the right to work, then you might not be able to continue employing them. And that's at the point at which we'd have to start considering dismissal. So there's some steps to take first, and we've seen it before where, understandably, clients almost have a bit of a knee-jerk reaction. The thought of legally employing somebody, they might jump straight to dismissal when actually they would be expected to follow that process and establish what's going on, and do everything they can to check that right to work first, in case there are circumstances in which they do still have the right. But if you are in the position where you've done all of that and they still can't evidence their right to work, then we'd have to consider dismissing them. And in terms of an unfair dismissal claim, then you might be familiar with the 5 fair reasons to dismiss. And I think in this case, we'd be looking at some other substantial reason, which is a sort of a catch-all, or illegality. Their employment would breach a statutory restriction. And it's important, if you are facing this situation or a claim, on these grounds to get this bit right, to get the reason you're relying on for a fair dismissal right. Because there's case law in the past, and we've got on the slide there the case of Baker. In this case, the employee failed to be able to show their right to work during internal audit. The employer dismissed the employee on the basis of illegality, but it transpired that the employee did in fact have the right to live and work in the UK. They weren't subject to any immigration control, and there was no requirement for them to leave the UK. So it went all the way to appeal tribunal, and they held that the dismissal was unfair because it wasn't illegal. So for that employer to continue employing that individual, they wouldn't have been in breach of the rules, the immigration rules, by doing that. So where they fell down there, the issue for them in that case was relying on illegality. A safer option would be to rely on some other substantial reason. So like I said, it's a catch-all, but it also applies in situations where there's a mistaken belief. So if you followed a fair process and you still reach a conclusion, a genuine conclusion where you believe that that person doesn't have the right to work, if that is a mistaken belief and you've relied on some other substantial reason, then you're going to be in a better position to defend that claim. So that just points to sort of have in mind when dealing with this. I guess the last thing to consider as well, if you are having to dismiss somebody, is the notice with some other substantial reasons. So you should be terminating with notice unless the contract expressly says that you can dismiss them without notice in that circumstance. It's also worth considering if you have the ability under the contract to pay in lieu of notice. That way, you're not breaching the contract by terminating it wrongfully, and you bring in the employment to an end immediately. So again, it avoids any suggestion that you're employing them illegally. So it's a tricky area. There's sort of lots of different factors to it, various risks. So if you are ever in the situation where you're faced with somebody who can't prove their right to work, and you're sort of having to go down the road of dismissing them, we'd always suggest getting legal advice for the various reasons that we mentioned. I'm conscious that that was quite a quick run through, but I think, not to scare anybody with that. I think they're just important to remind ourselves of the other employment issues at play when we're looking at immigration and sponsorship. We've got 5 minutes. Does anybody have any questions or anything that they want to sort of look at further whilst we're still here? I'll turn this back on.
Nothing from me.
Nothing from me. Thank you.
Perfect. Well, our details are on the slide there for both myself and Alan. As I mentioned before, and as Joe mentioned, the local enterprise partnership are offering an hour's slot with us to follow up on anything specific you want to explore, obviously funded by Cumbria LEP. So what we'll do is reach out with our details after this, so you've got our contact details, and if you want to set up that call with us, then we can look to do that. And Ian, I know you obviously would like to look at the issue you're having with the certificate more, so that's something we can chat through. But if any questions once you've had a chance to digest crop up, then please feel free to email us and we can pick that up with you.
Good stuff.
Okay.
Well, thanks for attending, everyone, and hopefully catch up soon.
Yeah. Thanks very much for that.
Thank you. Thank you.
Cheers, guys.
Everyone.
Have a good rest
Thank you
of the
for
day.
your help.
Cheers.
Anytime.
Take care.
Bye. Bye.
Bye.